That lunch was enjoyable, and we know I'm excited and raring to go again. So very quickly, first of all, our panel discussion is going to focus on the Data Protection Act and the implications for citizens and for government. We have three panelists with us, but I would like to make apologies for Senator the Honorable Lynette Holder. She's running a little late, as well as Shannon Clark, who is our other panelist. My third panelist, Bartlett Morgan, and I will start the dialogue, and they will join us when they arrive. So very quickly, Bartlett, as you may have seen on his page, essentially is a technologist who has turned to law. So currently, even though he has a law background, and traditionally there are certain elements of law with regards to commercial disputes and employment law, he spends a lot of his time dealing with the law and the intersection between law and technology. And that really relates to how do we deal with some of the issues around data protection, IP disputes, online defamation, telecommunications, and blockchain-related issues. So Bartlett is my guest here today, so we get a bit closer.
Yeah.
Interestingly enough, we both started to have this conversation around the Data Protection Act even before this session started. So what I would want to do is to just give a very quick overview. So for those who may not be aware, in the last few months, the government of Barbados, having recognized the need for improving the way that we protect data and how we provide data privacy at the national level, went ahead and drafted, through Parliament, passed the new Data Protection Bill of 2019. And the genesis, or rather not the genesis, the basis of this bill really speaks to how do we regulate the collection, keeping, processing, and dissemination of personal data. How do we protect the privacy of individuals in relation to their personal data, and to provide matters related to those first two related points. And that really means that it covers issues around the principles associated to data protection, rights of data subjects. So data subjects will be people like yourselves. So in theory, we recognize that data belongs to you, the individual. So as a data subject, what does this law mean for you, and what rights does it confer onto you? The Act also talks about how do you deal with the transfer of personal data outside of Barbados, other related exemptions. So for example, you would recognize that there are particular cases where the government may need to have access to your data in order to carry out or to execute its normal business. And as such, it may need to have some exemptions from the traditional approach to data protection, which the citizen would always have complete ownership of their data in every scenario, meaning you could in theory say to government, I would like to have the right to be forgotten. And as you would appreciate, there will be a number of implications associated to that if you did it. So with Bartlett here, without further ado, so that we can start the conversation. From your perspective, could you give me your view as to why this legislation is important and why now?
Okay, so it's a good question. So if you want me to say why the legislation is important, there way you can say there are two answers: the right answer and the truth. Mm-hmm. I mean, let's be frank about it. The reality is, we now live in an era where data is far more important than it's ever been.
Yes.
In large part, most of the services we use and partake of and derive value from, they're data-driven. And so with that in mind, and with the market going behind data and looking for ways to make use of and to provide services and so on, it's far more important now to offer some amount of protection to the persons that the data relates to, i.e. you and me. And so in that context, it more or less makes a case for why you need an act like this to provide protection to everyday people for information that relates to them, because it's just so ridiculously valuable. I remember about 2 years ago, The Economist put out a report, and it said that oil is no longer the most valuable resource to human beings. It's now data.
Yes.
And so that, I think, provides some, I guess, context to why it would make sense to pass legislation like this. It's also, I think, valuable from a completely different perspective as well, which is from the perspective of businesses and so on. There is actually a dollar sign value to good data protection practices
Yes.
in a number of ways, and in ways you probably wouldn't even think of initially. So, for example, I mean, I work in a corporate commercial firm, and so it gives me the luxury of seeing how certain transactions have changed over the years. And nowadays, let's say a business is looking to acquire another business. One of the things you know doing your due diligence, as of course, is to check your data protection, your history, and your systems in place, and what's been your history of breaches and that kind of thing. Because now you can say, well, there's a dollar value to that, and by extension, it raises questions about the value of your business.
Yes.
To relate this to the larger conversation we've been having today, certainly, there's the question of trust.
Yes.
One of the things we've come to realize with time and experience is that people tend to adopt and use things and engage with people that they trust, right? That's a basic tenet of life. You trust somebody or something, you tend to engage with it.
Yes.
We've found with experience in other jurisdictions that when you do have something like a data protection regime in place, people, everyday people, are more likely to trust using online systems and to start engaging with them because they know that if something goes wrong, they trust that there's a recourse.
Yes. Yes.
And so in that larger context, you know, it also, I think, justifies the value of this, certainly from a business perspective as well, in addition to the traditional reasons.
Yeah, and I would tend to agree with you. I mean, clearly, as we move to becoming digital societies, the more and more we are going to collect data, whether that be data that's collected in the private sector, whether it's collected in the public sector, whether it's collected in academia.
Yeah.
And then the question becomes, how do we make sure that we have the frameworks that support and allow for the proper use of this data to
Yes.
some more, hopefully more positive end.
Absolutely.
So, I mean, to follow up to that as a question, I mean, based on how the legislation is designed and constructed, I mean, what is your view on some of the key components of the legislation and how those components support and facilitate this trust that we're talking about?
Good question. So, to answer that question, I think it requires a sort of a bird's eye view of this new legislation. And just to give some context, the government of Barbados, the parliament, perhaps a month and a half ago, they actually passed the Data Protection Act. And so it's on the books now, save and except that it's not proclaimed, and so you need to be proclaimed for it to actually have effect. Now, if you take a bird's eye view of it, one of the things you'll realize is that it, in essence, it facilitates the trust and building of trust because of one fundamental thing. I say all the time, when you take a broad view of this act, it comes down to two words as it regards the persons who are going to be handling your data, whether they be government, private sector, what have you. Two words: be reasonable. That's really what it comes down to. And I say that to say, the first major section of the act, right, it deals with what you call the sort of data principles that ought to be applied by anybody who's processing your data. And it speaks to things like data minimization. So if I am running a business or I'm offering some service as the government, I should only take the data that I actually need to provide the service. And I should only keep that data for as long as I reasonably need it and no longer. And I should certainly put in place reasonable mechanisms to protect the information. And so there are other principles like this, but the point to be made is this. Once these principles are being adhered to in general, it creates an overall environment, or helps to create an overall environment of trust.
Yes.
You need that trust as almost the cement or the foundational blocks to build this. I mean, we've been talking about smart Barbados this entire week.
Yes.
And smart societies and so on. That is one of the foundational elements. If there is no trust, nobody's going to use any of these fancy services that we've talked about and the concepts that we've said, this could do this and change Barbados in this way. If you don't trust it, you're not going to use it.
Yes.
And so in that sense, when you look at it in that way, the Act, it creates all of these obligations on the persons to process your data so that the sum effect of all of them, in the main, it won't be perfect, is that there will be generally a feeling of trust in doing business.
Yes, and I think that is, again, to the point, is going to be key. It is key and necessary.
Yes.
I mean, if you put it in the context of the fact that if you understand what's happening in the European Union, with the passage of GDPR, for which it would appear as though there are elements of our legislation that follow from that, the world is moving in a direction that says people should have the right to make sure that the data is well protected. They should have the ability to determine who has access to that data,
Yes.
who are the third parties that data could be shared with, and again, this whole point around the right to be forgotten and so on.
Yes.
I mean, if you were to compare and contrast to some degree what we see within the GDPR legislation and Barbados' Data Protection Act, would you be able to give us some comments on the difference? And particularly, I would like you to speak a little bit about some of the exemptions, which I think may differ a little bit.
Okay. So, again, good question. So, contextually, just to set the stage, a few years ago, the European Union passed a piece of regulation called the GDPR, General Data Protection Regulation. And the idea behind it was to offer a comprehensive framework for protecting the rights of persons in Europe. And it included a number of the provisions you'd expect to see in data protection type legislation. The stuff I spoke about earlier, you know, data minimization and security and that kind of a thing. But it also went beyond that to introduce some other elements, you could say, that are considered new and certainly cutting edge. Things like, you know, their articulation of this right to be forgotten, for example. That's a huge one. You know, just the idea of having astronomical fines, things like that. You know, it's a big part of what they introduced to the game, so to speak. And it's generally considered to be the gold standard nowadays for data protection legislation. So in Barbados, what we've ultimately ended up with is a piece of legislation that is, I would say, heavily inspired by the GDPR, but it's not identical.
Yes.
So like if I were to take a forensic reading of our Data Protection Act, what I would say is that we took the 1998 Data Protection Act from the United Kingdom.
Yes, yes. Yeah.
We took the foundational principles from that, and then we took a lot of the newer concepts that you find in the GDPR, and then we stuck that on at the end. So that's a rough and dirty sort of articulation of what we have.
Yes.
You know, and so in a way the question is also, well, based on what we have, is it fit for purpose?
Yes.
Is it useful?
Yes.
That really is the underlying question.
Yes. Yes.
My own assessment is that yes, it is. That is a different from question from saying, is it perfect?
Yes.
You know, it probably isn't. I mean, most reasonable persons could look at the legislation and point to things that are perhaps, you know, arguably not suitable for the times. You know, I know quite a few persons within the business community, for example, have argued that the fines are perhaps too large, and perhaps that the obligations for small and medium-sized businesses, they're just simply too much for them to reasonably comply with. And so there is that question as well. I mean, I don't want to drag on too long, but the whole question of difference and the approach that we've taken and the end result, I would say this. In a climate where it was an absolute necessity to get it, I think it's far more important to have gotten it, and gotten what, in my estimation, is not, by any reasonable standard, a bad act.
Yes.
In fact, certainly in the Caribbean context, this is by far the most sophisticated legislation that I've seen recently, and I've been tracking this over the years. It's by far the most sophisticated in terms of how future-focused it is, and the fact that it contemplates lots of the technological realities that we're now faced with in 2019 and going forward. And so I think those are to be commended.
Now, just to follow up that point, I mean, you raise a couple of things that raise a couple of questions in my mind, and again, these are some of the things we started to talk about earlier. I mean, one of the things that's noted in the Act is, again, this whole question around the exemptions for central government.
Yes.
In terms of the limiting legislation around use.
Yes.
Is there some discussion that we need to have around whether or not there needs to be some further governance framework or structure that looks at how government onto itself is going to be able to comply with its own legislation? Do we need to have a discussion as to whether or not there is a line of potential for misuse that we need to determine what is that line? Who will take some accountability to be the watchdog to make sure that line is not crossed? And I only bring that in the context of when you look at some of the challenges that you see in the United States now, where you have politically the scenario where the elements of government are now being used in a very raw political way for misuse.
Yes.
And we know that we do have some of these exemptions, which I think they serve a good purpose. There's a double-edged sword. And so
Yes.
what are your thoughts on how we deal with that aspect?
So here's what I would say. And again, relating this back to the whole context of what we've been talking about all week, about smart bar base and so on. There is an argument to be made that the reality is government needs to function above anything else. And so the things they put in place, including the legislation, it needs to sort of create that or walk that tightrope between creating new rights and new avenues and mechanisms for enforcing those rights, and it's the reality that government, at the end of the day, doesn't need to be even more hamstrung. It already is in some ways, and you're trying to make it more efficient and workable and smart and what have you. And so the reasonable argument is, well, we shouldn't put legislation in place that has the effect of making government even more inefficient in trying to comply with the legislation. And so if you use that as the sort of framework for the analysis, the question then becomes, are some of the exemptions in our Act reasonable that apply to the government and what have you? I can't tell you, I don't think I would come down on the side right now of saying they are completely unreasonable.
Right.
Have they perhaps gone a bit too far in creating exemptions for themselves? In some cases, yes. So there are certain things that you'll see in the Act that you can't readily rationalize why those exemptions are there for government. So things like, for example, files held, and I'm using layman's terms here. I'm trying not to lawyer this up. Essentially, the government has a bunch of files and they're strewn about, not in a coordinated way. Whereas if you're in the private sector and you have the same situation, you have an obligation to get your house in order, based on all the principles in the Act. The government doesn't have that obligation. To me, I'm not sure what the value of that exemption is, because what it's essentially doing is creating an implicit incentive for the government to not digitize and to not put systems in place that more than likely would inure to the benefit of everyone in the context of a so-called smart society.
Yes.
So in that sense, I do think there is some room for having those conversations about reworking some of these exemptions. There are also larger questions too, because there was a sort of political element to your question. I may have misread it, but you've painted a picture of the things that have happened in other jurisdictions where essentially you may have the executive sort of misusing, misapplying its power or abusing it. Or whatever.
Let me clarify. And again, I'll pull the example that we kind of discussed this morning. So sometimes if we look at the example that says that if you went for a certificate of character, you provide the police force with your fingerprint, and the whole purpose of providing the fingerprint is for them to be able to validate that you do not have a criminal record. But based on how the legislation is set up, that fingerprint, which now identifies you in a database, now has to be destroyed because you're not a person of interest to the police force. Now, if you take that as an example, should we not also make sure that our Protection Act from a governmental standpoint still has these mechanisms that ensures that there are not cases where, because you may have to provide a level of carte blanche access because you're a government, that line is pushed. And and again, it creates a bit of a challenge. So those are kind of, to my mind, the areas where, it's going to be difficult. I think whether or not we need to look at how we either expand the role of the commissioner, and we started to have that discussion, whether the commissioner's role in part should include some level of compliance as a recognition that government may not be able to comply with every element because it does need to be able to conduct certain types of business. But how are we managing that? Or is that a function that really now belongs within the Auditor General's? And does the Auditor General's office even have the capability to be able to take on that particular role?
So that question might require some unpacking. Yes. So if I miss half of it, forgive me.
Sure.
But let's tackle some bits of it. The general sense I got from the first part of it really has to do with a larger question again of, well, how much is too much? How much in terms of the balance between the rights of people and the obligations of government and the exemptions that are created for the government in terms of handling your personal data and so on. What I would say is, in the main, and this is just a general response, is that one of the beautiful things about the Act is that it comes with with a lot of checks and balances.
Yes, yes.
You know, and so whereas certain things may appear to be an exemption or a carte blanche, they actually aren't, because there are other provisions. So like you remember at the start of this conversation, I spoke about the general principles that are in this Act, you know, data minimization and security and so on and so on. Those tend, even if one of the exemptions in the Act apply to, you know, with few exceptions, those principles still have to be observed by you. So you may not have a specific obligation. For example, you may have an exemption as a government entity from, let's say, for example's sake, you know, doing an impact assessment. For example, I'm just making this up, right? But that doesn't take away the fact that you still have to abide by the other obligations generally in terms of how you handle the data, which includes things like transparency. You know, if someone were to ask you a reasonable question, well, what kind of data are you holding on me? You should give them a reasonable answer. I'm holding this amount of data. I've been holding it for this long. I've been using it for this purpose. Things like that. So there is that element of balance in there, and which is also a part of why, and this is perhaps a segue, why I encourage persons to actually have a read through, have a scan through of the Act. I mean, you won't become an expert overnight on it, but it'll give you a good sense of just certainly the amazing new rights that everyday Barbadians have.
Yes.
You know, because I think, and I'm totally segueing, but I think it's important to mention that, you know, acts or different acts of parliament, they're only as valuable as we actually, you know, make them in terms of actual use. You know, and that is a big part of it. And so people need to be aware of the whole panoply of rights that you now have, that you didn't have before in Barbados.
Yes.
Yeah.
So I'll just stop you there. So
My
Shannon,
apologies.
Yes, no problem. So I hope you were hearing some of the conversation as you were coming in. So we were talking about a little bit about the fact that, you know, even though they are people that may have a view that there are elements of the Act that may have its challenges, that may infer maybe too much either exemptions or too much power on of government to skirt what would be the elements that would make up general data protection and privacy. So to your mind, I mean, you know, what is your thought and your view as to the Act, its fit for purpose and the balance in that it has to carry?
Okay. First, apologies everyone for my late arrival. But I will first start by saying that I think that the Data Protection Act is definitely timely and it's really necessary. It certainly fills a lot of legislative gaps, both for practical reasons, economic reasons. And then also, I mean, some persons even say that government is just ticking a box, if you want to be devil's advocate, just ticking a box in terms of the EPA requirements. However, what I would say is that, towards your question, we need to come to the point that Bartlett was mentioning. What is the purpose of the Act itself? And towards that aspect, I think if we're looking towards a digital Barbados, we want our citizens to be able to utilize technology not just as consumers, but also as creators. And certainly we want them to be responsible creators.
Yes.
And we want them to also have confidence in terms of the same e-government applications we will have. So for instance, now government has Easy Pay, I think it is, Easy Pay Plus.
Easy Pay, yes.
Right, exactly. So we want to have the confidence that our financial data and our own private data is not going to be leaked to any third party, and those third parties that are working with government are held to stringent requirements. So I think the Data Protection Act certainly lays the baseline for that.
Yes.
Now, most of my concerns really are in terms of the implementation and also our own willingness to learn also from some of the same challenges that the GDPR has. I'll just make a disclaimer, I am not a lawyer, that's why Bartlett is here. However, as a tech entrepreneur, I see it from both ends. There's a massive opportunity for tech entrepreneurs now that there's the Data Protection Act to say, okay, well, essentially look to all small businesses now, not only within Barbados, but potentially even within the EU, and say, we provide this secure system. Or we can customize our software in order to meet your own data requirements and regulations.
Yeah.
Huge opportunity. However, I'm deeply concerned when, just as Bartlett mentioned, some, well, in terms of the education that's happening. So many businesses are indeed looking at the bill and certainly understand that there will be some impact, but maybe not all of them understand how much of an impact. When I had the opportunity to sit down with a medium-sized firm and walk through the bill with them, they were indeed very shocked. Not necessarily in terms that the bill is overreaching, but in terms of the number of requirements placed on businesses. I don't think that these requirements can't be addressed and can't be met, but I think certainly we need to consider the difference between proclaiming the bill and then enforcing it, and what would be a period of education
Right.
as necessary, you know. So, because I know a lot of businesses will want to get ahead of the data commissioner essentially knocking on their door,
Yes.
and so he say, hey, I am good, you know, I can prove it to you, put that forth. Which business would not want to do that?
Yes.
But at the same time, many businesses also wouldn't want the issue that of limited engagement, for instance, and that's why panels like this are really important,
Yeah.
so that then businesses can start to say, okay, what are the 10 steps I need to take, for instance, in order to start preparing?
Yes, correct. So in the interest of time, I would like to open up to the floor for questions.
Do you believe that the Act provides enough differentiation between or among the data in the sense, for example, absent specific legislation that deals with health information? Is health information at a certain level as equal to, let's say, personal data like, you know, age, gender, whatever? And I'll give you a specific example. Something like HIV status, right? The ramifications of a disclosure of HIV status in society, in the workplace and stuff, has far more deleterious consequences than, let's say, if I had a sore throat, right? So do you think that the one act can cover specific examples like
Yeah.
that, or do you need to compartmentalize
Gotcha.
the
So
legislation?
I'll let Bartlett answer that as a question, and he may make comment based on
Yeah.
it.
So the short answer is, I hate to lie it up, but it depends. But here's the reality of it. I want to go directly to the heart of your question, using the example you just gave. So how this act is structured to work is that in addition to just your personal data in general, there's a separate class of data referred to as sensitive personal information. And so in that class, you have things like health and health-related information. And so one of the implications of the act is that if it falls into the second category, there's an even higher sort of compliance standard that an entity would have to abide by as regards how they handle that data. And obviously for the direct reason that you've raised, the implications of a data breach that relates to sensitive personal information, it's far more deleterious
Yes.
than regular information. If you know that I went to Burger King last week, okay, but if you know that I have HIV, I might not get a job from you. You know what I mean?
Yeah.
And so the short answer is in fact yes. But to answer the broader sort of philosophical question that you've raised, which is the whole idea of, well, an American style approach, which is go by industry versus the European style approach, which is one law for everybody. The truth is there can be and is a happy middle ground, because even in the Barbadian context, there is no work afoot on credit reporting legislation, which in effect, when you look at the draft, it really is specialized legislation for a particular industry.
Yes.
And so we're sort of doing both. We're ensuring that the society in general has a certain baseline. Everybody in general has to comply with this baseline. And then in addition, in certain particular industries and so on, we may have legislation to deal with that. But in addition to that, and it actually goes back to a question you had sort of raised somewhat to do with the data commissioner
Yes.
and his role and his remit. A big part of his remit will be to, in consultation with particular industries and sectors in society, come up with particular codes of practices that go beyond what is on the face of the act. And so, for example, in the healthcare industry, to use your example, they may well come up with a code of practice that comes up with even more specific practices about how you handle data and health-related data. So I think that's the response to that question.
So the larger issue, and I guess I'm sort of asking it rhetorically, are we, from a legislative perspective, are we better off with ad hoc legislation or trying to get craft legislation that is so broad in scope and reach that it becomes all the more difficult to enforce.
Yes, I think the short answer is that you require a mix. And it depends on the particular sector, it depends on the nature of the data they tend to deal with in that sector, and the degree to which most of that data is sensitive and so on. Because on the face of it, as I've suggested earlier, the reality is this act does create that special class. And what's also interesting is that in addition to the matters identified in the act,
Yes.
it gives the minister a power to add additional things to that group of sensitive personal information. And so let's say in our context, we realize, my goodness, we're not paying enough attention to what's going on in the insurance sector. There are too many breaches going on. The minister has the power by order to add, let's say, personal information related to your insurance status. And I'm totally just making up this example on the spot. To the class of sensitive personal data. So to put it another way, the approach we've taken, it can work. It demonstrably has worked in other jurisdictions. But that isn't to say that the American-style approach doesn't have its place.
Good afternoon, guys.
Afternoon.
I guess it's going to be Bartlett, but anyone can answer if you're comfortable with it. If I have a concern, would be one that came out of Jamaica, because Jamaica's Data Protection Act came online a little earlier than ours. And one of the concerns that they had was the level of acceptance, or a situation where when you start, you're a region, we do cross-border trade. And all that trade, because we're service-oriented, is data.
Yes.
So, I know we need the Data Protection Act. My question would then be, what happens to cross-border trade in countries that do not have a Data Protection Act, so they can't comply to adequacy? Because part of the Data Protection Act says that a country must be adequate. But one of the reasons why the GDPR came about was because every EU country had their own version. So to make it simple for all those people here who might be wondering what we're going with, every EU country had a Data Protection Act. But the problem was every act had its own flavor. So imagine every Caribbean country, that speaks English, have an accent. And sometimes you'll be communicating with someone and you cannot understand them because the accent is so harsh that you start misinterpreting what the person's saying, although we speak English. So the question would be, all right, how critical would it be, for one, to get other countries up, and we can lobby, Barbados is a very powerful vocal country, get everyone up to a standard code, or do we see ourselves going in a direction where we need to now have almost a CARICOM level standard that is now
Overlaid.
overlaid.
It becomes the umbrella standard for CARICOM.
Because if not, we can have a strong act that is not adequate, where other people may have their own Data Protection Act. We want to do cross-border trade.
Yes. So, Shannon,
That's
I mean,
for the lawyer.
you want to pass that one to Bartlett?
That's for the lawyer. That's for the
All
lawyer.
right, so, I think there are two questions in there. Well, the first one was, what happens when you're doing cross-border data flows with a country that doesn't have any kind of regulatory framework in place? And then two, with a Caribbean sort of framework. So the first question is, thankfully, one of the criticisms that members of, I guess, the wider committee would have leveled at prior drafts of the Data Protection Act in Barbados was that in the context of international data flows, it didn't allow for situations outside of where the Barbados government has designated, let's say, Jamaica, for example, as having an adequate level of protection, and therefore it's lawful for data to flow between those countries. So the latest iteration of the bill that actually became the act, it now allows for two different things that would allow a workaround that situation you raised. So they have something called binding corporate rules. So which is where you have let's say a regional company, let's say a Digicel, for example. So Digicel has binding corporate rules that apply to all the companies, to all the entities within the Digicel group, that includes provisions to do with protecting your data. And if that BCR is approved by the Data Commissioner here in Barbados, it then puts them in a position to now continue to have data flow throughout the world outside of Barbados. The other situation is, well, you're one entity here in Barbados, maybe you're a service provider. You're providing some service online or via the internet, and it requires data to pass out of Barbados, but to an entity that's not related to you. They have essentially what you call standard contractual clauses that you will now have to insert into whatever arrangement you have with that entity outside of Barbados. And that those clauses will have to have certain provisions in them that allow for a certain baseline of protection of the data of persons in Barbados.
Right.
So that's the first thing. The second question is one that has no clear answer. essentially, well, how do we raise the standards and ensure that we have a sort of, a fairly strong framework across the region to make it easier and more practical for us to do stuff. So that actually was a discussion that we had at the Trinidad Internet Governance Forum at the start of this year, that same issue, because the reality is in the Caribbean context, it makes sense given the way certain businesses operate.
Correct, yes.
You're based in Barbados, but you're doing lots of stuff in St. Lucia. You have some software solution and you're actually offering it, through the cloud, persons in Jamaica, wherever. It should make sense that the legislative framework is such that it facilitates that without you having every time you get a new customer, you have to know, insert some contractual clauses and this and that. It's expensive and time consuming. Yeah. And so I think there are different potential answers. We've tried different things already. So for example, there was this project going back about 10 years ago. It was called HIPCAR.
HIPCAR, yes, I remember
And
that.
the basic idea behind HIPCAR was to come up with like standard model type legislation that each country in the Caribbean would then implement to do with everything to do with technology, from telecoms to data protection, computer misuse, you name it, interception of data, all of that stuff. But the challenge that faced was when it came to the implementation phase, each country took the model and so heavily modified it for their own purposes that the different bits of legislation that came out, it wasn't exactly on par in a number of ways.
Yes.
So for example, to use data protection as an example, there are some countries, for example, St. Vincent. St. Vincent doesn't have any sort of breach notification framework, which we now consider a critical part of data protection in the modern context. And breach notification is the idea that, well, somebody's handling your data, something goes wrong, they now have a legal obligation to tell you and or tell whoever the regulator is. So there are examples like that. So that didn't completely work as planned. The other option is to have a sort of treaty-level arrangement, similar to how we have the CSME. And essentially what that would do is basically guarantee at the treaty level that there are certain rights for persons, and it guarantees that data can flow within the region and so on. That's a potential solution, but again, practically it may be expensive and time consuming to implement.
Well, the point on, first I want you to be able to make kind of a last comment because we're wrapping up, but I mean, if I follow Bartlett's point, I to be honest, believe that the CSME route probably is one of the better routes, because when you appreciate the overall framework of what CSME is supposed to be in terms of the free movement of people, business, and so on, then it would fit neatly under that particular framework, because we're now moving to try to create greater linkages that allow for us to integrate more economically, even though we're clearly not ready to put the E on there as yet. The fact is that these are some of these stepping stones that we need to think about and to undertake. Look at the projects that are being done by BIT and what have come out of the ECB and their projects for cross-jurisdictional digital transactions and payments. Clearly, we need to begin to wrap ourselves around how we will deal with this across the region. Any final comments from you on that, especially from a business perspective?
I mean, with regards to from a business perspective, I'll just echo a lot of what Bart has also mentioned, but in terms of with regard to like, okay, let's say a software service provider wanted to offer not only within the region, but again, even into the EU, this would potentially facilitate that, because it basically says that all companies within Barbados have to reach this standard, right? So we are already, even though Bartlett did mention it's probably from 1998, probably not from 2018 as we desire, but I think it definitely says that we are at this certain standard. So then it really comes down to the individuals within the industry then to either identify further with required certifications as necessary. But one of my questions then, really and truly, would be, if we have a regional body or a regional treaty, for instance, would that perhaps also give us potential protections against the larger internet giants who actually have most of our real personal private data? That is my question, and maybe that's a question that also can be answered right now by anyone, not necessarily Bartlett, but if you really think about it, most of our private information is being stored there. So
outside of Barbados.
Yes.
Right, exactly. So I don't think that's what the act is trying to do, is really focusing on, okay, let's set a stage for them building towards the digital Barbados, or the digital transformation that we all speak of.
Yeah. So I know that there are two people, it's just that we need to wrap up given time. So because you were standing, you still want to ask, but the answers will have to be very quick.
Good evening to all. My concern was also shared. Sorry, I'm also sharing the same concern as the first gentleman in
Yeah.
terms of our personal information, because I know that our information, as you just said, sir, is stored overseas. Most of the government information. The last thing we need is our nitty-gritty details scattered all over the world. America already has sufficient problems trying to get their own messes handled in terms of protection of the privacy of their own citizens. I would like to know what does the legislation that exists at present, is it adequate enough to really assure us Barbadians or the Barbadian public that we are really safe and secure with our health information in these databases? Because I, for one, am not too thrilled about it. I'll be perfectly honest. And I would like to know, in keeping with this Smart Barbados innovation, at any point in time, will you guys be looking to start chipping people? Because really and truly, you know, you start on one level and then you graduate, and you know it turns into something that really gets out of control. I personally,
So-
once again, let it be stated, I'm not interested in it. But the Indians have already done that from years before. So I would like to know if that is the direction that you all will also be headed in, and what assurance can you give Barbados that we will at some point have a say in that? No, I don't want to participate in that aspect or this aspect.
Right.
Can
So-
you do that?
Yeah, well, unfortunately, I would like to answer the question, but unfortunately, we're out of time. So one, I would like to, give you the opportunity to come and speak to Bartlett or to Shannon after, who may be able to give you their insights. But one, I would like to thank Bartlett for his time and his insights today. I believe they've been very, enjoyable, because we do share some similar views around the current data protection legislation. Shannon, again, though truncated, we would like to thank you for your time as well and for your insights.
Thanks.
And we would like to thank the audience for your questions. Thank you.
Thank you. All right. Sorry, got it.
Thanks, man.